Now, what I would suggest is that if you can't personally handle them, be careful of what you do because there are consequences. Now, she can directly fine him in contempt of her court, probably up to the maximum because the events occurred in front of her, and they're also, in addition, pending criminal matters that, well, not pending, but potential criminal matters, which I think the state has already charged him with. So that could be something that occurs. Somebody, by the way, is dragging something around.
Yeah, I know. I'm just going to close mic for a quick second. Yeah, because I can't figure out who is what and where's it coming from.
Got him.
I'm glad that happened, actually, because, guys, we're getting ready to open up the mics. So if you got background noise, please, 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 because we do play this on other platforms, and it's annoying when you listen to the playback and there's all this background noise and people can't hear what the speaker, the person talking, is saying. Also, you know, Judge, he rules this court right here, right?
Let me be candid, Miss Valerie. Let me be candid. God damn it, hit the mute button when your ass ain't talking so we don't get fucked up and can't use what somebody else says. Now stay on your game. Hit mute until you talk.
Hit mute until you talk. We need to make a T-shirt out of that, Judge.
Yeah, there you go. That's good.
That's a good phrase for the show. Hit mute till you talk.
All right, I'm going to welcome
mute till you talk.
So I opened up about 11 mics. Guys, please, 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 please be mindful of your background noise. But if we're not familiar with your position or, you know, your voice, please announce yourself. And, let's get this thing started.
You want to get Judge Joe Brown on it? You want some Judge Judy up your booty? Mm-hmm. You better lawyer up. You better lawyer up. Lawyer. You better lawyer up.
The convicted felon who just recently attacked a judge in Clark County.
I saw the video.
Insane. What are your thoughts on that?
I was actually shocked that this defendant managed to get as far as he did without somebody shooting him. But it probably happened in a second. That once he was there, there were too many people. But I was actually shocked that somebody managed to get as close to her and on top of her. I dealt in the family court with some issues that were at least as profound as being jail sentenced, terminating parental rights, abuse of children. And there is always that risk that somebody will act out, and you just have to hope that you have support staff that will get there before they get to you.
I mean, he had perfect
He was like a projectile.
Yeah.
He was like a projectile. And that kind of anger and total lack of self-control is so dangerous.
Mm-hmm. All right, Judge, 1, do you recognize the
My
voice?
reaction,
2, what's your response?
I thought the whole thing was a mute. I thought the whole thing
was
was
do you recognize the voice?
Yeah, I know, and it's on her. See, I found that that's Judy. See, I found
that's
it
Judy,
amusing
correct.
Because one of the things that's inherent in this law that she never learned, she never got exposed to, is the judge was not just the judge. His lordship was the baron, the earl, the knight, the warrior, the king, the chieftain, who was the local badass. And when you put yourself in this situation of dealing with people's lives, you become an integral part of the process. And it's not just up to the people in the courtroom to protect you. They've got your back, but you have to be able to protect yourself. And a lot of women do not get it. That when you start severely impacting people's lives, and when you act like Judge Judy does, who shows no demonstrated judicial temperament that is appropriate, you start depending upon everybody in the courtroom to protect you from hostility and anger that may develop. Your bailiffs are not there to die for you. Your bailiffs are there to maintain order and you have a reciprocal obligation to maintain the order. And if somebody comes after you like that, you have to be prepared to take them on. Now, when he dived, I said, oh, look at her. She's watching him like she's on notice. But if she had been somebody who was privy to, say, martial arts, a man or a woman who had been trained in this thing, she would have said, okay, he's leaping. I could make a strike to the chin in this direction, snap his neck, or when we get down there, of course, I'm carrying my sidearm, I'd shoot him. So we would have ended the tale, and that would have been all to it, and everybody was, oh, my God. And, well, we wouldn't have to worry about somebody's mental illness and recidivism. But you see, she wasn't able to do that, and 4'7" tall Judge Judy with her 85-pound self is used to everybody taking care of her while she acts ugly and precipitates rage going on in her room. So her set was 10 feet from mine on the same sound stage, and we taped on alternate days or weeks, and we had some of the same people working for me. So she would jump up when she got through doing something until she saw that I told the Hollywood type, I'm eyeballing the guy. If he doesn't like it, come on, get it on. And a couple of times on the show, I said, okay, stand down, turn the cameras off. You want some of this, come get it. And I never had that happen in the courtroom, but I can remember where we had some organized crime stuff and somebody was a co-defendant with a case that was in another courtroom, and they had the SWAT team in there. I just said, look, let me turn the record off, Madam Court Reporter. I said, look, you son of a bitch. I said, I'm listed in the phone directory. If you and your homies want to have, well, you can't since your ass is in jail. Your homies want to have a visitation and some excitement, look me up. Now, let's get back to this no more bullshit. Keep going. See, there's a way of handling it.
that part. One more thing.
People get it because they're not used to consequences. When you mess with people's lives, particularly in domestic matters, that's when people get shot. It's almost never that you get this mess in a criminal case because they assume that the prosecution's going to be after your ass, that the police are going to be after your ass, and it's up to your lawyer to keep them from doing what you're going to do. And if the judge does anything, it's because your defense lawyer didn't do something. So, I mean, you got to be a real live jerk to get somebody going off on you for a criminal case like that.
One more thing, Judge, and then we're going to...
the way the woman handled it. She had a tone that goes along with, I'm going to whip your fucking ass because I'm the bad person up in here when it comes to mixing it up. So that's how I'm talking to you like this. Now, if you want to challenge that, fine, here I am. But if you can't handle that, then don't go there. So I laughed. I just said, yeah, I see a lot of that now. I said, so I told some colleagues, I said, watch what you're doing because you may provoke something you can't handle. Well, I've got 4 bailiffs. I said, but they can't get up there in time. Can you handle it?
Hey, family, it's Valerie Denise Jones. Pardon the interruption, all right? I need to slow this thing down just a little bit because the audio I'm about to introduce is of a very, very serious nature. Kyle Massey's situation is still ongoing, so I want to show the utmost respect to all parties involved, all right? So as a disclaimer, this is a part 1 of 2. Part 1 of 2. This, of course, and the part 1 will feature the full interview betwixt Judge Joe Brown and Angel Massey, and also I'll probably throw in some of the audience's reaction. So, that'll kind of add to the story. Angel Massey and I have partnered to bring attention to her son's story. So please, please, please stay tuned for Angel Massey's story regarding the dark side of Disney, whether you should get your child into acting, et cetera, et cetera. So I'll be showcasing that here in just a bit. But until then, please enjoy this audio and meet me down in the comment section, okay? Bye.
Down with the defendant, Kyle Massey. What can you tell us?
Yeah, Jesse, Kyle Massey, the former That's So Raven Disney star, is being charged with immoral communication with a minor. At first glance, it seems like a simple case. The question being, did Kyle Massey send a minor sexual materials over the phone or internet? But after sitting with Massey and his attorney, this case seems anything but simple. The fact is they're alleging is that you knew this young girl from the age of 4, and you knew the family, and that there was some sort of communications that the relationship with you, I've seen them describe you as a father figure almost to this girl. And I love the reaction because I want to get into that as well. And you were supposed to marshal her through the industry, so to speak. I've even heard allegations that you supposedly said that she can come and live with you from Seattle to LA with you and your girlfriend, and you would help her in this endeavor of trying to become famous. And that, a month or 2 after that invitation, that's when you were on her Snapchat, you sent allegedly some photos of someone that looks like you, who might have been nude, and sexual photos. Those are the allegations, from my understanding. Yeah. I'm going to try to give it to you first. What is your response to those allegations?
My response to those allegations are that, first off, we would need to go back. Let's go back to the mother of this kid, right? You stated in your paperwork that I've known this kid since she was 4 years old, right? Yeah. Well, the truth about my relationship with that mother is that mother had a inappropriate sexual relationship with me since I was a kid, when I was 15.
So let me expound upon what Mr. Massey is saying. So there is some discrepancy on when the date that they actually met. The mother in this case is saying that they met in 2009. Mr. Massey alleges they met in 2007. So based on Mr. Massey's birthday, which anybody can Google, that's a 15, 16-year-old versus a 17, 18-year-old. So, and then that's where she advances this whole thing about her daughter, he's known her since she was 4. Now, if you look at the police report where she gave her statement to the police, she said Mr. Massey met her at Universal Studios, California, California, and that she was with her children, other adults in a group, and that Mr. Massey approached her from the group and was trying to get her phone number. Now, if that's the case, then how would Mr. Massey have known any of the children present belong to her or belong to anyone else? He's just seeing you in a group of individuals, and that's just using what she has said. Mm-hmm. I'm not saying that this is necessarily the case, but this is her version of events that she gave to police. So she's attempting to use that, if you will, to try to set out that he's known the child as if he met the child directly. He never met the child directly. There was no interaction with the child.
Is the video something that was meant to be sent to like another adult?
Yes, the
video
was.
And then it was like, right, this could be something that is wrong if it's sent to a child, but I did it accidentally.
Correct. And the issue is that there's no feeder conversation leading up to this. There's no, oh, let me send you something. Oh, why don't you? There was no segue.
Yeah, no flirting,
no flirting, all the communication is straight-laced. When she's saying, oh my God, blah, 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 how you doing? It's, oh, I'm good. How was your day? Oh, I'm fine. There's no communication where Mr. Massey is soliciting photos from her or she's soliciting photos.
Now I can sit here and I can like look at you and say it without breaking down. But you gotta understand, this is like one of the hardest moments in my life because the person that molested, raped, took advantage of me when I was a child is now painting me as the predator.
Yeah, so we'll continue to follow Kyle Massey's case out of Kings County, Washington State, as he awaits his trial, which is scheduled now for July.
All right, so she is going to help us fill in the blanks, but also talk to Judge. I'm going to actually fall back.
Yes.
But before I do that, I have to give credit to the law, because copyright. To Law and Crime Network. That's where I got the audio clip. You can find it there. It was on YouTube. The title is Disney Child star Kyle Massey speaks publicly about criminal sexual misconduct charges against him. And the voices you heard, of course, was Mom and the young Massey.
No. That was the voice that you heard was
that wasn't you?
His attorney. No.
Oh, okay. You guys sound alike.
No. Her name is Ariel Mitchell. That was his attorney that accompanied him on that interview.
Gotcha.
That was a 2-hour interview, and her name is Ariel Mitchell.
Thank
Attorney
you so much
Ariel Mitchell, Esquire.
for clearing that up. All right, so at this time, what I want to do, because I want to fall back, I want to give you a chance to talk to Judge and help him fill in the blanks, and then ask him, whatever you, your heart desires.
Okay.
So let me do that. Welcome, 323-646-323646. The man, the myth, the legend. He is in the building. How are you doing, sir? Happy New Year.
Well, yeah. Hi, ladies. How you doing? All right.
Hey,
now, what is it you want to inquire of me?
Well, yes, sir.
What is it you...
Do I go first?
Go ahead.
So my name is Angel Massey, and thank you for having me and allowing me on your show, sir, Your Honor.
I've been listening. Go ahead.
So what I wanted to share with this platform here is, first of all, that whole situation over in King County, Your Honor, would you believe me if I told you that they actually made up a whole entire arrest document? It's called a super form. And they made up so that's how we ended up in that jurisdiction. My son has never been to that jurisdiction before. He's never been served at all to even be in that jurisdiction. We didn't know anything about that. They made up a whole previous conviction document that never existed, that created a felony warrant. And they have just continued to snowball with these lies and these made-up documents on my black male son. The prosecuting attorney over there, his name was Daniel Satterberg. He was unopposed over there for 16 years, and then a whistleblower turned him in for nepotism, and his only consequence was that he got to leave and not run for re-election anymore. And the whole case against my son is made up. The girl even told her, the prosecutors, the detectives, when she went, that she had never filed a complaint against him, which she did in California, and the judge dismissed the case. Also, I would like to say his whole accusation is based upon a Snapchat. These alleged documents, these alleged videos and pictures were, according to the mother, was sent to her daughter via Snapchat, through her daughter's Snapchat account. Well, King County subpoenaed Kyle's Snapchat account, and there was nothing on his Snapchat account that was anybody communicated with anybody under 18. So the problem is, when TMZ released the story, it's just been a story that's hanging around out in the universe, and because King County doesn't want to admit that they made a mistake and that they screwed up, we're just sitting on someone's desk with my son's life just being in limbo since June of 2021. It will be 3 years, June of this year. They never interviewed the little girl. They don't have the original phone that all of this was supposedly happened on. The lady gave a thumb drive to the detective, and my black male son his life has been in limbo for 3 years over a thumb drive, and the Snapchat came back squeaky clean that he had no communication with anybody under 18. I've just never seen anything like it. Okay. So that's why I would love to ask your opinion about that. How old?
Well,
my son, how old is my son?
Yes.
My son, he is, right now he's 32 years old.
How old was he at the time of this alleged occurrence?
Well, originally it was, he was, so that means that he would have been 31 because it started back in 2019. The lady tried to extort us.
Now, hold on. How old was the alleged victim of this at the time of the occurrence?
She was supposed to be 13 years old.
13. All right. Now, you're saying it's a blackmail attempt? What are they seeking to get?
I'm sorry. Yes. Originally, back in 2019, she sent a demand letter demanding that we give her 1.
Who is she?
The mother.
The mother of this daughter. All right.
Yes.
Okay.
Yes, that was having sex with my son when he was 16. And in California, the legal age to consent to sex is 18.
I understand, but he's a male. Okay. And how old is she right now? The mother of this child?
She was 37 at the time. Well, she was 37 at the time that. Well, she's 37, I guess. She's 37 because she's 7 years older than him.
Okay, well, that's inconsequential in terms of that. But the point of it is she, according to your version of facts, is long acquainted with your son.
Yes, sir.
All right, so she's trying to extort money from him. Is that what you're saying?
Yes, sir. We have the demand letter to prove it.
Okay,
yes,
what was the demand letter before all of this? Was this demand letter delivered before all of this became formalized?
Yes, sir. The demand letter she was demanding $1.5 million in exchange of her not going public. And that was back in 2019. And the judge in that case in California dismissed the case.
Okay, I got that. That's in California. Okay, that's not a case. She was just making an informal demand, right?
Well, no, sir. She actually filed. She originally sent us the demand letter. I understand your question now. 1 month. She gave us a demand letter 1 month. She was demanding us for over a month. And then after we did not comply with any of her demands, we didn't do settlement, we didn't talk, no mediation, we didn't do any of that. She went and filed the case, formally filed it in California, and then the judge in California dismissed the case.
This is something that apparently is alleged to have occurred in California, right?
Yes, sir. That's right. Yes, sir.
Okay, now, where is this currently pending case located?
In Seattle, Washington, in King County, Washington, Seattle, Washington.
How did they acquire jurisdiction?
That's just it. That's where it gets really tricky because the police actually made up an arrest. So we went through two attorneys.
Wait. You can't make up an arrest. You can allege one, but where is this arrest supposed to have occurred?
Yes, sir. It was supposed to have occurred at the King County. The address where the arrest happened was at the King County municipal building, which is the jail. But they have a super.
Wait, hold on. What state was that?
Yes, sir.
Washington,
the state of Washington. Washington.
Okay, what does that arrest have to do with the facts being alleged that your son purportedly did something inappropriate toward a 13-year-old girl?
Because the arrest said that he got arrested for immoral communication with the 13-year-old girl in Seattle.
Where did this Okay, so they are saying there's a prior event that occurred in Seattle.
No, sir. They're saying that they arrested. Well, the way you asked that question, I'm confused.
Well, I'm getting down to the nuts and bolts of this. See, in other words, for a state court to have jurisdiction, the action that is complained of or the conduct that is complained of has to have occurred within the county wherein that state entity is located. So what is it that they're claiming occurred in the state of Washington in the county where this arrest took place?
They're claiming, according to the arrest, the super form, that he he got communicated immorally with a immoral communication.
So they're saying
that
this occurred. They're saying that this occurred in California, in Washington, right?
They're saying that they arrested him for it. They have a whole
no, that's relevant where they arrested him. Where is the conduct supposed to have occurred that resulted in the arrest?
Yeah, they're saying that it happened in Washington, in King County.
So they're saying that your son allegedly committed this act in the King County, Washington.
Yes, sir. But also remember, they still have.
Hold on. Next question.
Yes, sir. Yes, sir.
The events that you're talking about that occurred allegedly in California that resulted in a dismissal, is that supposed to be a series of events that occurred at the same time as the alleged series of events that supposedly occurred in Washington?
I love that question, and that's I guess that's what they're saying.
Well, in other words, where was the young girl supposed to be when this occurred? Washington or California?
Well, see, that's a great question because we don't have the phones. We have not been able to do a forensic on the phones.
No. It's not what I'm asking you. What is the allegation? Is that the girl was in Washington?
Yes, it was. Yes, sir. It was in Washington. Yes, sir.
All right, and you say that contemporaneously there is allegations that this happened in California. That's what you're saying.
I'm just telling you
what I've been listening to.
I'm just telling you what their complaint is.
No,
their complaint.
That's what I'm asking you. Is that the allegation that they've delivered? In other words, they're saying that on or about the month of X, this communication occurred that originated in the state of Washington, but you also have something that's saying on or about the same month, this communication supposedly occurred in the state of California. Is that what you're saying?
Well, what I'm saying is, one was civil in California. The civil lawsuit was in California, and the criminal is in Seattle.
It doesn't make any difference. Where did the events occur? She sues in California. For California to have jurisdiction, the communication would have had to have had some connection with the state of California. If the same communication is supposedly to have something to do with something that happened or originated in the state of Washington, it doesn't make any difference whether it's criminal or civil. It would have to have occurred within Washington's jurisdiction. Now, the fact of the matter goes down to it might hinge on where your son was at the time. Was he by any chance on or about those dates alleged in the state of Washington?
No, sir. He's never been to the state of Washington ever as an adult.
He's never been to the state of Washington. Now,
no, sir.
You
never.
say you were there as a child, when he was a child?
Well, yeah, no, but doing PR for work for Disney, but that was when he was a little kid, maybe 9 or 10 years old. But he's never been to the state.
That would have been 20 years previous to that there was some connection. All right, that's outside of the time zone. Well,
no. What I'm saying, what I'm saying is he's never been there as an adult unattended.
Fine. We don't have any conduct that allegedly that you know about that would have occurred or could have possibly occurred, either originating from or winding up in the state of Washington. Now, a question: was this girl supposed to be in Washington?
She did. That's. If we had a good attorney,
no, that's not what I'm asking you. Focus.
Okay.
Is the state of Washington claiming that this young girl was in Washington when this offensive allegedly occurred?
Yes, sir. Yes, sir.
So they're saying she was in Washington.
That's what they're saying. Yes, sir.
Okay. Now you have a factual circumstance. You have what under California law would be a sworn complaint.
Yes, sir.
And if you have a sworn complaint that would give jurisdiction to the state of California, apparently that would be because your son was in California. And you have a situation where Washington is claiming that he called from California or communicated from California.
Saying that it happened over Snapchat. They're saying that he sent all this happened over Snapchat.
In other words, let's get away from what the hell else the social media entity is. But they're alleging that he was in California when he communicated with her in Washington.
They're not saying where he was. They're just saying that he communicated with her, but they haven't specifically.
Okay,
said
so they
where
were
he was.
saying that they're saying she received a communication from him while she was in Washington.
Yes, sir. That's what they're saying.
Judge, if I could play the audio clip.
No, I don't want to hear the audio. I don't want to hear the audio.
I'm talking about Inside Edition and TMZ.
No, I don't want to hear TMZ. I don't want to hear the garbage on tea from TMZ and Inside Edition. That's not evidence. And I have actually had quite a number of cases that I tried for real as a criminal court judge over the years that were on some media event or covered by court TV or something like that. And they weren't even close to what the facts were that developed.
No, you were asking her what did they allege, so that's what I was trying to say.
No, I'm not talking about TMZ. I'm talking about the state. And I assume that since her son is involved, she's taken a more astute interest in the proceedings than TMZ.
Absolutely.
Now, so, okay, what the theory is that this girl who was in the state of Washington, who was somewhere around or about 13 years of age, received an improper communication from your son who was somewhere, not necessarily in the state of Washington, but caused a communication to be delivered to her that was inappropriate. All right? Now, as part of the defense I've been hearing is you're trying to attack the credibility of the complainant, that is the mother of this 13-year-old child, and say that she has been engaged in an effort to extort and or blackmail your son. And this is just carrying out the threat. So you say, amongst other things, it's a matter of diminishing her credibility. She herself had been engaged in sexual impropriety with your son when he was a minor. And, in fact, well, let's get over the minor status. That's really kind of iffy, but she has an ulterior motive because it's not that they are unknown to each other. It's not that they're strangers. She, as an older party, initiated a romantic liaison with your son, and she's getting revenge for it. That's your theory, as I hear it. Is that what we're talking about?
Well, that was in her demand letter. If we didn't,
give her the money, she was gonna. Oh, yeah, I got it. So, in other words, she's carrying out the consequences that were threatened as part of an effort to commit extortion, a.k.a. blackmail.
Right.
So your son did not succumb to the blackmail attempt, and this is what she's doing to carry it out. All right. Now, perhaps what's going on is the communication that was offensive was sent to the mother, or the mother got the communication when she was having this romantic liaison with your son when he was still something of minor. All right. Is that what we're saying here?
No, sir. No, he was grown. The communication.
Okay, well, you're saying then, listen. You're saying then that this allegedly offensive communication was part of the interchange between your son and the mother of the purported victim when this mother and your son were having a sexual liaison.
Yes, sir, that's
right. That's what you're implying. All right. Well, that becomes a matter of credibility, and that would be up to the jury. I don't see, since it's a factual dispute here, that there would be any technical basis for the dismissal unless there was something in the interest of justice that showed some sort of inappropriate action that should be developed from a thorough investigation of the matter, but that would be something that would have to be shown in front of a jury, and the state would have the burden of proving beyond a reasonable doubt that the alleged crime committed. Now, you have a lot of material for a good defense lawyer to work with in keeping that credibility from being established and to do what they call impeaching the credibility of the state's case. All right? So that ought to be an interesting trial.
Can I tell?
Go ahead.
Listen. Can I tell you? Can I tell you this? Like, oh my gosh! Like you, I would love to know if you've ever even heard of this before. So the case is not even going to trial. Okay, they already trying to get him to do a plea deal, and they forged the document internally, waiving his right to a speedy trial. This happened June of 2021. And
who signed the document? Who signed the document?
The prosecutor. The prosecutor. Listen to me.
Okay. No, listen to me. Listen to me. Who signed it on behalf of the defense?
The prosecutor.
No, you can't sign it for the defense counsel. Did your son have an attorney?
Yes, sir. Listen to this. Listen to me, Ms.
No,
Your Honor, Judge.
It doesn't make any difference with the rest of it. Did his attorney sign off on the waiver of the speedy trial?
No, sir.
All right. Now, was the waiver of a speedy trial hooked up with anything else like a continued investigation?
No, sir.
All right. Was there a hearing before a judge in open court wherein your son was asked whether he waived speedy trial considerations to allow the investigation to continue?
No, sir. My son has never, still to this day, been to King County, Seattle, Washington. To this day, it's been since that.
So he's not been arraigned yet. So
that's a great question. So yes, so the arraignment, they claimed that they sent a subpoena, what you call a subpoena to him to an address that wasn't ours, and it came back to the court 4 days before the court date was on the document. It's recorded in the court on the court docket and everything. They proceeded to have court without him. We didn't know nothing about this. We're blind. We found out about this.
Let's stop. What you're giving me is grounds for any of those proceedings being nullified because there was inappropriate service. The defendant did not have notice to appear, and there is no valid reason to proceed in absentia or with him being absent and not present for the proceedings.
That's
so
right.
They issued a warrant for his arrest, I take it.
Felony warrant because they said they made up a previous conviction for the same behavior.
Okay,
my son
all right, okay, all right. They're saying that they have a prior. In order for sentencing to proceed accordingly, they'd have to prove beyond a reasonable doubt that this previous arrest incident actually resulted in a conviction. You cannot, under American law, as decided on many occasions by the U.S. Supreme Court, the Supreme Court of the state of Washington, as a matter of fact, and others, you cannot proceed upon a mere arrest. They have to have a conviction for this in the past. So if they want to have enhanced sentencing, then they have to prove beyond a reasonable doubt that this previous conviction occurred. In order to do that, they would have to have a bifurcated process. You would have to have a finding of guilt of the underlying charge, and then when it came to enhanced sentencing or punishment, you would have to prove the allegation of a prior conviction beyond a reasonable doubt to the same jury. Now, what they're trying to do is make this more serious by coming up with an alleged prior conviction in the state of Washington against your son. So
yes,
that is an allegation. Now, has he posted a bond yet? Or has
We've
he ever
We've never been to the state of Washington. We've never done anything.
So there's an outstanding warrant, and they're seeking what, extradition?
No, sir. None of that.
So what are they trying to do? Are they asking that he come and surrender?
No, sir.
Well, you have information that there is a pending felony warrant against your son. This is something that would otherwise be a misdemeanor, but for the fact that there is an allegation of a prior conviction for the same thing, which ramps it up to a felony status. Is that what we have as a situation here?
We have a case where the prosecutor actually signed. We got a new attorney. The prosecution attorney, the prosecutor, her name is Laura Harmon. She actually signed on the where the defense counsel was supposed to sign out for what you call substitution of counsel. All of this is we hired a firm. We had to hire a firm over in Seattle. Okay, so that firm was friends with the prosecutor. The prosecuting
now
attorney,
everybody knows everybody. I mean, you sit down for lunch,
right, and
maybe
signed,
you meet up for happy hour, so it's no big deal.
Right, exactly. But let me tell you what she did. Our attorney, the attorney that we had before we hired this guy, she signed off for him. There's no bar number. There's no signature. She signed her name.
You don't have to have a bar number. If the person's an officer of the court, their own word will suffice. Now, so that's what the question was. I asked you, did anybody sign off on behalf of your son?
No, sir.
I asked you that earlier.
Well, it was a prosecutor. She did.
She signed on the dotted line, not your son's defense counsel.
No, sir.
Is she claiming that she was direct? Is she claiming that she was directed to do so by defense counsel?
I don't know what she's claiming, but her signature is on there. And the dude that we had, that was our attorney, he was originally pro hoc vice, and then he fired the guy, and then we were left without an attorney. That's why we had to get another attorney in Washington. So was he allowed to still work if he fired the guy that he was under pro hoc vice?
If he was allowed to withdraw by the court from representation, no, he's no longer acting as counsel. Now, that's why I
I'm talking about
you,
before that.
Well, all right. Well, ma'am, the question still goes back to this. Did anybody sign either actually or representing that he was doing it on behalf of your son when it came to the waiver of the speedy trial considerations? Did anybody do that?
Not from our. Cal never gave anybody permission to do that. All of these documents. That's why I started out saying all of these documents.
That's not my question. That would have been my next question in sequence. Mm-hmm. I'm asking you if anybody did that. Then the next question would be, did your son authorize this being done?
No, sir. My son has not authorized anything. He's never signed anything. Okay. He's never been there.
But he's 31 years old.
Mm-hmm. He's 32 now.
31 at the time. Well, to give you a frame of reference, at 31 years old, I was the chief public defender in Memphis running the public defender's office. So this isn't like he's a child. He's a grown man at 31 years old. Been so for 10 years at common law and anywhere else in the country. At least buy whiskey and do everything.
That's right.
Now, so okay.
Yes, sir.
So we're talking about what a grown man has to say. Now, what I'm getting is a mother's story. I haven't heard from your son, and I wouldn't want him to discuss it because under American law, that Fifth Amendment, anything you say can and may be used in evidence against you, and you have a right to remain silent, which in criminal cases, almost 100% of the time, the best thing to do and talk through your lawyer. Keep your mouth shut now. So I wouldn't even ask him.
Yes,
but
sir.
I'm getting the story from you, and there's some questions you can't answer. So, again, what I'm listening to is a factual dispute, which would have to be proved to the satisfaction of the jury beyond a reasonable doubt. The issue of enhancement from a prior conviction would have to be proved beyond a reasonable doubt in a subsequent proceeding in the event the defendant was found guilty of the primary charge. You have ample material from what you're telling me to really cast the issue of credibility, accuracy, and veracity when it comes to the complainant or the chief witness for the state in terms of their proof. So this ought to be an interesting trial.
Yes, sir. So let me. Can I share something else with you that may kind of help you clear up what I'm. So we got a new attorney, right? We ended up getting a public defender. So we got a new attorney. So
sometimes they're the best. Sometimes the public defenders are the best lawyers in the courtroom.
So let me tell you what he did. I love him right now. He's like a superhero right now. The first hour of him being assigned to Kyle, he sent a 3-page demand letter for discovery asking for the body cam footage from the arrest, the police patrol car footage from the arrest, the jail footage from the arrest, the two-way communications from the arrest, the witnesses that booked Kyle at the arrest, Kyle's previous convictions, his dispositions from the previous convictions, all witnesses, all states. That's, Your Honor, that's what I'm telling you.
So they have
all of it is made up.
So in other words, you're saying they have none of this because
they
it
have
didn't
none
occur.
of it.
Well,
Zero
let me
minus
say
zero
this. Let me say this. You're still not off the hook. They still have to prove it, so you really aren't on the hook, but the hook is there because we think in terms of the last 5 to 6 years, but you've got a couple of thousand years worth of ancient law here where nobody thought of anything like body cams and the footage with the booking except as something that witches, warlocks, and sorcerers might construe. So the basic form of evidence is good old eyeballs, good old earballs, Mark 1 edition of both, and what was heard or observed. So that's how stuff depends. So they don't have to have body cam footage of an arrest. That's only superfluous. There's nothing in American law that requires that. That's just practice for PR purposes. Now, is there any witness who's going to attest that we booked him? These are the papers. This is the documentation in terms of what was going on here? Is there anything like that?
Are you asking me? No, sir.
I mean,
never
but
been
do you?
there.
I'm not. Well, you okay? Your story has never been there. Now, I will say this: what your lawyer, your son's lawyer, can't discuss this past a certain point with you. It's not like he's a minor, so he's not obligated to. And oftentimes, what the mothers hear is not necessarily what the defense counsel may know or what has been admitted to him by a grown defendant, but I will assume that you're giving me an accurate recitation of the allegations that you are familiar with. All I'm saying right now is as long as the state is proceeding based on what they have right now, which is sworn complaint, a sworn complaint backed up by a sworn affidavit detailing what is put in the complaint, they can proceed to trial. Now, your son apparently has not yet been arrested. I'm interested to know how he wound up getting the public defender's office appointed. Has he been to Washington since these charges occurred and been arraigned? Or booked,
no, sir,
or anything like that?
No,
he's
sir.
Never been. He still is outside of Washington.
He's never been to the state of Washington.
No, I'm talking about right now. He's not in Washington. He's not in jail. He's not been arrested.
No, sir. He's never been there ever. Still to this day.
I'm asking you right now. Is he under arrest? Has California detained him with an extradition request, or what?
That's why it's so confusing.
Okay.
It's a made up
Okay,
case.
how did
you
get the public? How did you get the public defender's office to represent?
I'll tell you why. I'll tell you because they kept, like I keep saying, they were making up these documents, right? And so they kept on having court dates. I kept looking online. We kept looking online on the site, and he kept having court dates and what they call omnibus hearings, and they kept having all these things. So when we had the attorney. We had an attorney. Then we didn't have an attorney, but we kept looking at the docket. So he had a omnibus hearing coming up for trial date. Okay, so we ended up.
Look. There's no way in the world a major county in Washington is going to have a trial date set for somebody they have yet to arraign.
I know.
They will not appoint the public defender in absentia. Somebody's got to appear. How? Okay, my question is this. I'm not asking if he was in Washington when this is alleged to have occurred. I'm saying since these charges were brought, has he been to Washington to contest them? Has he made an appearance through counsel? Has anything like that happened?
They did make him he did a Zoom one time, and that's when they took away his internet.
That was a couple of years ago when COVID-19 was hit, right?
Yes, sir.
So he has made an appearance, and he has been arraigned, and they appointed a public defender. Okay,
no,
I
sir.
get it.
He did a Zoom meeting in 2022.
That was because at that point in time, everybody was excusing people's personal attendance because of the COVID-19 epidemic. So he appeared.
What they did? Well, he never got served, right? So he never got served.
He put in an appearance, and he's entered a plea, and the public defender's office got appointed to represent him. Or we had two regular attorneys. We had two regular attorneys first. But now you have a public defender. Yes, but if he would not have the public defender appointed, were he not actively reporting to court after an arraignment? So he got arraigned.
We never reported them. We only did that one time arraignment.
Now you do that through his appearance might have been waived, but his attorneys have been appearing for him. How often the defendant is out of the country? Your Honor, may we excuse the defendant's appearance so that he can appear in absentia through counsel? Yes, sir, you may under the circumstances. Now, that happens. So he's been arraigned, and he's got a report date, and there is a trial date that's set. So right now, I think it is whoever is representing him is preparing for trial, and what you're telling me is that there are interesting witnesses who would cast a great cloud over the credibility of the complainant mother.
Yes,
and
sir.
The complainant mother would be tainted as a witness because she had an affair with your son, who's a 30-some-year-old man, and she was thwarted and attempted to blackmail him. And you have the written demand for compliance with a blackmail request. Well, if there was a felony that occurred, she does not have the authority to resolve the matter. She could have, in fact, been compelled to be a material witness and locked up until she was gave testimony on behalf of the state of Washington, or been required to post a material witness's bond. So what she is engaged in, according to your side, is allegedly an act of extortion, to wit blackmail. The blackmail did not succeed, and there was a retaliatory, fictionalized complaint that came about. And you are perhaps alleging that the incriminating evidence actually got sent to her during the course of a sexual relationship she had with your son, not to her daughter. That's what you seem to be saying. All right.
That's right.
Well,
And
then
his subpoena.
I don't want to hear about the subpoena. No, the subpoena is just technical to get stuff in place. It doesn't have anything to do with the facts of the case that are alleged.
Okay.
The subpoena is just to compel the production of evidence and attendance of witnesses. It comes out of the Constitution of the United States, or at least the Bill of Rights.
I understand that the press has their, they have the right to report and everything. But if they, in my son's case, his attorney at the time and TMZ were friends. He was relying solely on TMZ to get him the information and the transcripts and the docket, and they were having backdoor email conversations without Cal's knowledge and everything with Cal's attorney at the time and TMZ. We paid that man like $30,000. We paid him $30,000, and he never filed a motion. The first motion, the first piece of paper that was filed was from the attorney that we just got in October, and it happened in June of 2021. Is that okay? Is that still considered freedom of press if both of them are lawyers and they backdooring and communicating about the headlines against Kyle?
Look. Have you ever played bid whist in college with some of your friends?
I played spades. I don't know how to play bid whist.
Turn right.
Have you ever played spades with some of your friends and everybody's been drinking and everybody is vicious and throwing down? And there you go. How about take that? Or had a tennis match with one of your buddies, or a game of golf and bet a few grand or a few hundred on the next hole of the back nine. You see, even if you are acquainted, and it's inescapable for acquaintances to develop in a profession, does not mean that you are deviating from what you're supposed to be doing. It's like Sarge, you mentioned, or somebody mentioned, that they were proud of the judge in spite of what had just happened to her coming back out. Wow. Well, somebody's in the car. But anyway, the judge went ahead and imposed the sentence she had dictated rather than doing something else. He followed the law relative to the sentencing. See, that's what people have to do, and it's inescapable for folk to do this. See, this is what's happening when you emasculate the country. Some of the most famous battles in history, some of the most vicious, were proceeding by the contestants meeting up to drink, eat, and feast, and play chess before they slaughtered each other the next day. Now, that's just a man thing. You, on the field of honor, you adhere to all of the formal protocols before everybody takes 10 paces, turns around, and tries to kill the other one. See, so it's not unusual that people know each other. But what is wrong here is when you deviate from the rules, because here's one of the problems. Every time for the last 50 years that the American Bar Association, National Bar Association, the local trial lawyers, etc., survey the judges and lawyers and prosecutors, it develops that less than 25% have actually read the Constitution. Everybody has to study it in some aspects when you take con law in your first year of law school, but many don't give a damn about its application to individual rights. They just pay attention to the commercial money-making aspects. So very few people who are charged with applying the Constitution have actually read the damn thing. So that is one of the problems.
I have one other question for you based on that. They took away Kyle's ability to be able to use the internet. Was that considered unconstitutional, or was that okay?
I have no idea what the circumstances are and what goes on in the state of Washington. That could be a restriction on his bond circumstances or on bail.
He never did a bail.
He's on bail at these charges.
He never paid a bail. He never have a bail. He doesn't He's never
they
been
probably released him ROR. That's a bail. If you charge somebody, you either release them on their own recognizance or you have a bail.
He's never been arrested there. He's never been there.
Arraigned there. You have pending charges and a trial date. We went over that. He made an appearance through Zoom because of the COVID epidemic. That's what happened. His physical presence was excused, but he was present through an electronic device. They do that. You notice that during the OJ trial, they had some people in federal witness protection programs testified remotely, was sworn in, and they did it from a remote location. That happens these days. So that's generally acceptable.
It was 7 months later, and the only reason that they did that, the only reason that he did that Zoom was because they were threatening to do all 50 state
It doesn't make any difference. It doesn't make any difference why he did it. If he put in an appearance through Zoom and he was represented by counsel, it's the same thing. So that is probably, I'm not saying it's what's going to happen, but it probably would be construed as a condition of bail. Because as Sarge pointed out, they could file a request for extradition to the state of California on pending felony charges. Whether they could sustain it. The state of Washington could file, state of Washington could file an arrest and extradition request with the state of California to take your son into custody, hold him, and extradite him physically to the state of Washington. Because they've agreed to what probably is a recognizance bond. He doesn't have to do that, and his appearance has been excused for the preliminary proceedings. Now, that's what probably is going on.
But they kept rescheduling. It's a little bit more complicated than I guess that I can intelligently explain. But they've made up. I mean, I can't say this enough. I know because you're really good at what you do. So you translate everything with me under normal conditions and circumstances. But this case, they've made up the whole thing. Like they made the whole thing up. Like none of it is true. Like they just
look. It may be made up. But I can guarantee you there is a warrant supported by an affidavit of complaint, or at least there ought to be, and that's under oath. That's sworn to, even if it was a false swearing. If a grand jury has gotten involved and issued an indictment, that removes the requirement when the grand jury acts and says, we return a true bill of indictment and find probable cause that this crime was committed, and that we have jurisdiction over it. Now, what they're doing about his use of the Internet is superfluous because it's likely to be a condition.
What's that vocabulary word mean that you just said? What does that vocabulary word mean?
Superfluous. In other words, it's superficial because it has been set as a condition of his bail or his bond. In other words, we can go request extradition from California and in custody, in detention, extradition, and we could set a formal bond. Because we are not doing that, this is part of the agreement. He will not use the Internet. At least not to contact her. Now, have you seen a copy of this order that says that?
About him not being able to use the Internet?
Yeah, physical order.
Yes, yes, sir.
What did you see?
It's a part of his well, you know, we got it from the attorney. We actually ended up getting a independent attorney to kind of scan over everything.
I got that. So in other words, your attorney in writing has advised your son that he's not to use the Internet. Now, did he discuss with your son?
The judge did.
Okay, where is the order?
That's a great question. I have to see, because I was on the Zoom. I listened to her say it. I haven't That's a great question. Now that you asked me that.
Where is there a written order?
So if it's not an order, what does that mean?
You talk to his lawyer and ask him.
Okay, because I know I heard her say it verbally out of her mouth, but then I guess I do need to ask Kyle, does he have the order?
Well, that should have been transcribed some way or another.
All right, we got about 20-something minutes. Miss Massey, we're gonna have to bring you back when we do the part 2 and give you another hour. Do you have a question for Miss Massey, Chak, or what? I'm going on mute. Are you asking me a question? Oh, okay.
Yeah, I would ask
Miss Massey. I think Chak has a question for you.
Okay, yeah, no problem. Ask me. Go ahead. Yes, sir.
Yes, ma'am. How you doing this afternoon? I've been listening for a little bit. I watched a couple of videos on this situation because I am a father and my son is 17, so I'm really interested to see how this play out because I always teach my son and nephews and stuff teachable moments. You know what I'm saying? So I was listening to some of the videos, and I don't know if it was you said it on one of the platforms, mentioned that your son had dated the alleged mother in this case when he was underage.
Yes, sir.
And she's 7 years older than him. Why didn't you guys try to file some type of charge against her for sleeping, allegedly having sexual relations with a minor?
Okay, so that's a really great question. What's your name again?
My name is Chak.
Mr. Chak. Okay, so let me tell you what happened. When we first got the demand letter, Kyle went to Los Angeles Police Department to file a charge against her because what she did to him happened in California because she would travel over there back and forth. Her baby daddy is a rapper, one of them little rapper dudes. I think his name is Drew Downs or something, some little rapper dude. So he is that little girl's dad. And she would come back and forth to California. That's how she met Kyle, back and forth to California at some party. That whole thing about that her meeting that little girl at 4 years old, that was her narrative. That's a lie. That didn't happen. So that's how they started. And we used to live next door to a hotel on Vineland and Ventura called the Holiday Inn Beverly Garland Hotel. So anybody that's been familiar with California, it's a really kind of prestigious little boutique hotel. We lived right there next door to it. When she would come into town, he was 15, 16 years old. She would take him next door to the hotel, give him alcohol, they would do whatever, and then that's how it happened. That's where majority of it happened. So when he went to the police department in Los Angeles, they wouldn't touch it because when he went with his demand letter, they said that they can't do anything about it because she had that going on, which that's an excellent question because, again, the whole double standard thing, it's like, okay, he who tells the story first is not always telling the truth. And that's why this story is so complicated, and that's the reason why I can speak about it so confidently, but it's hard to explain it to. It's so funny because I was telling Valerie the other day, I said, normally when I get ready to tell this story to somebody, I always give a little disclaimer. I always warn them, now look, what I'm about to tell you is going to lower your IQ because none of it makes any sense. But here's the story. So with that being said, I really appreciate you asking me that. I also really, really appreciate and love the judge for being so open and honest and objective. And also, he can't even you can't even lower your IQ as low as what I'm trying to explain to you, all of the details, because all of those.
I've dealt with this kind of stuff quite often. See, one of the things is that there is a rampant distrust of people these days. It used to be if somebody made oath and or affidavit, it was true. And very, very seldom do people go back on their words or lie under oath. So that was an exceptional thing. That's why you have penalties for things like perjury. Nowadays, the presumption is everybody's lying. But now, crucially to what you say, she was 15 or 16 when she did this?
No. I said he was 15 or 16. She's 7 years old.
17. Nobody cares. 7 years older. If he's 16, she's 7, she's 23. He got him some nookie. Guy got laid.
Right, exactly. Right.
Fortunate guy.
Right.
Nobody's going to pay a bit of attention like that. He's not a girl, and I know what the feminists say, but that's bullshit. We just get into frankly, the thing, boy got him some nookie. He's
right.
16, she's 7 years old, she's 23, so he got laid, okay?
Right, exactly. But guess what? And I agree with you, but here's the thing. But then on the other side of that conversation, when you're trying to extort and when you're trying to, and what happened was in her original demand letter.
Hold on. Let me back to where the problem is. And this is what I talk about the bullshit that comes out of the press. We've had a lot of garbage that came out of New York's garbage about the saving statute they have where the statute of limitations ran. Right. And they're saying, well, you can go back, you're 74 years old, and when you were 16 and he was 17, you two were frolicking in the back seat of his Ford, 53 Ford he had renovated. So now, 60 years after the fact, you can file a complaint against him. See, everybody hasn't gone to that level of insanity. So it's way past being able to do anything about what may have happened when he was 16 or 17, and he's 15 years later, and he's in his 30s. So right. They're not going to pay much attention to that. And the point is that goes to her credibility as a witness, and also an implication if he doesn't take the stand and testify to it, it might be fairly raised from the state of the evidence that this affair is still going on again, and the questionable photos were transmitted to the mother, not the daughter, and she forwarded them to the daughter's phone number so she could have blackmail evidence.
Right.
Now,
stay right there, Judge. Let me ask you another question on that, too. Stay right there, because I had some, I wanted to ask another one, too, information I was looking at, too. The daughter is now 13 years old, right, ma'am?
No, the daughter, she's now, it's been 4 years, so she's 18 years old now. She's matured to an adult now. She's 18.
But the alleged incident happened when she was a minor, right? 13, right?
That's what her mama is claiming. But you got to remember now, just like I also said that the whole case, if you keep on looking on the internet, her whole complaint was that it happened over Snapchat. When they subpoenaed my son,
hold on, stay
Snapchat.
right there. That's what I want to hone in on, the Snapchat. What is the age for a child to be able to have a Snapchat? You need to look into see what the age.
Right.
I don't know what the age is.
Yeah, and that's the whole thing. And the age was over her age. And also, when they subpoenaed my son's Snapchat, his end. So if it's a communication, his end of the Snapchat subpoena, they went through his whole Snapchat account. There was no communication with anybody under 18, immoral or okay. He did not have any communications on his Snapchat that's subpoenaed within King County from the Sheriff's Department. It was nothing on his Snapchat under 18. So this is all because TMZ released the article in conjunction with that attorney that we paid $30,000. We ran out of money. We had to get a public defender. We paid that man $30,000. He never filed one piece of paper. The first piece of paper that got filed in the court was documents from a lawyer standpoint was just October of last year, 2023. Kyle was accused in court in June of 2021. None of the attorneys filed any documents. The only thing that they did was deferred and delayed to make it seem like that they couldn't find Kyle, that he wasn't available, they couldn't reach him. It's crazy. It's insane. Saying the games that they can play with people's lives. And my son has never, I can't say it enough, he has never been to that jurisdiction physically. He's never been arrested. That document is made up. They never released him on his own recognizance. That was made up. They never booked him. They never took his wallet, and they never did any of that. It didn't happen.
They don't have to. Look, ma'am, they don't have to book him. They don't have to do any of that. He made an appearance through electronic media with his physical presence being excused because of the COVID-19 situation. It was happening all over the country. Now, he's been arraigned.
How do you have an arraignment if you've never been arrested? How do you have an arraignment?
You don't have to be arrested. No. You get charged. See,
it's called the United States of America justice system. That's what it's called.
No, that's
unjust.
not it.
That's
what
it is.
That's not what it. That's not what
it is. Unjust though.
No,
it's
just
more
be
than
quiet.
unjust.
Just be quiet, son. Just be quiet. You don't know what I know about
it.
It
is. It's more than unjust.
When you
y'all do it,
stop,
that mean it's right.
Just
you
stop.
know that shit ain't right, Judge.
The expert, the professor, the person who's got a doctoral degree in this and 50 years
them niggas lie to you, man. Them niggas lie to you. Them niggas all understand. The prosecutor lie. The GA lie. Judges lie.
What are you doing?
Come on, man.
Would you stop being emotional and just listen? Young
man,
man,
I'm having a dialogue with you, brother. You're trying to take me out of
Put yourself on mute.
You're talking bullshit.
I don't document all the time.
Listen to the law. Listen to the law. You're not even close. You can be
not law. It's legal.
arrested.
It's not law. It's legal. Legalese what you're talking. I understand what you're talking. I'm just
saying
it's
unjust to charge you with a crime, per se?
What?
To charge you with a crime that's unjust?
The falsified document, you know it. Police do it all the time. Shit.
Sarge knows how this.
Do it all the time.
Sarge knows how this
all the time. You lie.
You
got the blue wall to protect you, man.
Will you stop
against this fake justice
Will
system?
You stop and listen
y'all don't want to hear
what
the truth,
law
man.
is.
People tired of it, y'all. People tired of this fake system.
You're illustrating
fake justice system, man. Now people getting justice,
You're
y'all. And if you ain't got money,
you want
and
me
it's
to
excuse me, this is LA. Can I cut in here?
Right.
This is LA. Can I cut in here? Can I cut in here, please? Please, Chak. You know what? The judge said from the beginning, you know, in each state, laws are written differently, and how they're worded determines what goes on in the case. The whole case went on along the COVID time, so everything was out of whack. They did what they could. You know, they have to find out for themselves exactly where they are in that case. It really does sound messed up, but it don't sound like they know exactly yet where they are either. And it would be better to hear from him. Mom, I'm a mom. I got sons that's wacko out here sometimes, but some that ain't. And yet they'll be portrayed as. You got to let them speak and let them say who they are.
Ain't been just to us melanated people in
Chak,
the United States of America.
Quiet so the woman can find out what the law is. You don't know what.
Man, I've been waiting online to talk, man.
I don't give a
when I come on to talk, you cut me off.
You are talking bullshit. Now, will you be quiet, young man, and let the lady hear what the law is? Now, the fact of the matter is what you posed was a valid question of sorts. You can get arrested by a citizen who observes the commission of a crime in his presence. You can be arrested by an officer who observes a crime committed in his presence. If there is probable cause or reasonable suspicion that there is a crime that is a felony that you committed, the officer can arrest you. If he takes you into physical custody or issues a ticket or citation wherein in lieu of arrest you promise to appear, that's one way to start things. Also, another way of starting it is when there's absolutely no arrest at all, but a grand jury acting independently returns an indictment, which typically in an organized crime situation is secret. Or it can return what's known as a presentment, where the grand jury, without anybody asking them, goes into finding out whether there's a crime. If there is a presentment or an indictment, there need not be a physical arrest. That is a formal charge. If there is an indictment or presentment, that supersedes the details of any damn arrest. So what happens is people do get brought in to be prosecuted who've never been physically arrested. I've represented such defendants. I have been present and presided over situations where that has happened. So when you charge somebody through an indictment or a presentment, what winds up happening is if they agree to appear, then you don't have to go through booking them. That is unnecessary. If they are formally charged, all you need to do is ascertain that you've got the correct person. If they appear through counsel, who is an officer of the court, and the counsel attests, this is my client, this is the person you're looking for, there's not a question of identification. The parties are well known to each other. Let's dispense with these formalities and get down to the nuts and bolts, which is, has this crime been committed, and can you prove it beyond a reasonable doubt to a moral certainty? And that's where we are right now.
Well, can I say something, though? Because I think I heard everything. I did hear everything that you said. The only thing that I will add is, in my son's case, there has not been any grand jury at all. There's no grand jury. It's only been that document that's considered. If everybody on the phone now, if you Google the super form, he filled out like you arrest somebody for real. Like he made it seem like he took Cal into custody. It's a whole super form document filled out.
Look. Hold on. Let me say that.
Law enforcement do janky stuff all the time. That's what I'm saying, man.
Excuse me. With
and they get protected. For due respect
of everybody involved, one of the problems here is we do not have access to the court's records. We don't know what's in them because we haven't had free access to them to inspect them.
Well, we just
Sarge, you know this, even the police have. Will you stop that ignorant bullshit?
Man, I've been waiting patiently to speak. Y'all been talking all day. I thought it was time for I want to have a dialogue with her.
I'm trying to advise this lady as to what the status of the law is. You don't know. So what
and I want to have a dialogue with her.
I don't give a damn.
I want to have a
Talk to her later.
If you don't mind.
Not now. Wait your turn. Be polite.
Y'all now, tough, man. That's the problem. Y'all
listen carefully. You're talking ignorance. You're talking ignorance.
Well,
now, you want to keep
going?
Go right ahead.
United States compared to y'all,
go right ahead.
That's what it is.
This is one of the problems
and that's
we have right now.
Hey,
people
man,
who do not know a goddamn thing about the subject.
I actually have another question. Please, I got my hand raised up. You all just can't see it. I actually have another question.
What is that, ma'am?
Is it interesting? Is it interesting that we're supposed to protect our kids, right? We all agree that Kyle was 16. She was 7 years old. He's 7 years old.
She's not 16 now. He is 16 years past that, and if he wants to do something about it, he's a man. He can do something about it if there is an avenue for redress. You can't get back into what happened with your 16-year-old child. He's not a puppy anymore. He's grown.
I know, but listen, Your Honor, this is what I was going to ask you. I understand. Listen, I understand what you're saying. So that was going to be. This is a separate question from that. If you let me get it out, I'm saying if we're supposed to protect our kids, right? We're supposed to protect, and it's a double standard because the women get to go back 50 years and accuse a man of stuff and don't have no evidence, and yet the young kids.
That's not in the rest of the United States. That is in the sovereign state of New York, which I said is filled with garbage bullshit from being politically correct instead of following the scheme of the law that is developed over at least the last 1,800 years.
What about Bill Cosby? That lady was 20-something years ago.
Excuse me. What happened was Bill Cosby's case got dismissed, as I said, before they went to trial because of Fifth Amendment deficiencies. It never should have been brought. I explained that carefully over and over and over and over and over again for the last several years. Now, I will say this. I've explained it earlier today, which is simply this matter. Well, I didn't today. I did to somebody else, another group. But it's like this. The office is what counts, not the individual that occupies the office. The district attorney's office said we have no intent of prosecuting Mr. Cosby. The civil judge said, therefore, since there is no liability to criminal prosecution, the court is ordering you to respond to this request for deposition. You have to respond. Now, at that point, the district attorney in question, who committed the office to this, left. A new DA disregarded the law and says, I don't care what my predecessor did, because in ignorance of the law, the goddamn fool didn't get it that his office had committed Mr. Cosby to rely to his detriment upon their representation. Therefore, they were bound by that. They couldn't go back and say we rely as part of our main case on the statement he made when he was ordered to do so for this civil case. The court, the Supreme Court of that state said, hell no, you can't do that. The liability is not there because the district attorney said no way, no how, and that commits the district attorney's office to that course. You can't come back and undo that. And that's the matter of the law, because there's a goddamn fool who held a position as an elected district attorney, and the goddamn fool was too ignorant to know the law. And that's what I'm talking about right now, is one of the problems in this country is stuff that any 5th, 6th grader used to know 55, 60, 70 years ago. Now is a matter of mystery even to appellate court judges. And I'm trying to banish some small part of the ignorance that attends this matter.
So what about the
I'm sorry, I'm not yelling at you.
No, I understand. I totally understand. But what about the prosecuting attorney in my son's case, Dan Satterberg, that was unopposed for 16 years and was found guilty of nepotism, and he was turned in by a whistleblower for nepotism and was found guilty of wrongdoing, and his only consequence was he gets to leave without rerunning for office anymore. But he's the one that did the previous conviction to get the judge to sign the warrant. Like, how does that not count for something when my son has not done anything wrong and never been to that jurisdiction?
Did you hear what I said? It's not the official, it's the office. And if the office did something wrong, then what winds up happening is there may be consequences. We don't know because there's no context for it. What is wrong in one instance is harmless error in another. That's what you have on many an appeal. It was error, but it's harmless. It doesn't have any impact on the outcome.
Yeah, I'd like to try to respond to Chak's emotion-laden statements just a minute ago.
To me. Talk to her, man. Y'all don't
I think I should. I think I should, because a lot of people respond like you, and I'd like to speak to every one of them who responds in the manner that you do. That's why I'm saying it. What you said is an example of what many people say, and we're trying to explain to you why you're essentially misinformed. That's what we're trying to do.
I'm not misinformed.
Chak. I'm the Chak. I'm not a Chak. I'm not criticizing you per se. I think your comments are representative of a lot of people, and I think we need to respond to those people, not just you.
Copyright disclaimer under Section 107 of the Copyright Act 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Nonprofit, educational, or personal use tips the balance in favor of fair use.